Commission versus DNL Apartments et al. We are being streamed on the web, both by audio and by video. If counsel who are arguing in this matter would introduce themselves by saying their names for the record, together with the party they represent, starting with the appellant.
Good afternoon, Your Honor. Carl Woke and Tyler Susi for the appellants of DNL Apartments et al.
Thank you.
Good afternoon, Your Honor. Colin Hurd, the appellee making the right.
Thank you. And Attorney Woke, if you're ready to proceed, we'd be happy to hear your arguments.
Thank you, Madam Chief Justice, and may it please the court. The issue in this case that we're hearing this afternoon is whether the Superior Court correctly applied or correctly read the law and applied the right framework in holding that the appellants violated two sections of the Maine Human Rights Act pertaining to service animals. With respect, the Superior Court got it wrong on both fronts. The first issue is in respect to the service animal section that is the impetus for this lawsuit. The lower court's holding betrays the purpose and intent of a section that is designed to protect disabled Mainers who require the use of a service animal. And the lower court's interpretation of that section expands protections to all Mainers in a way that is unnatural within the language of the section, illogical within the internal construction of the statute, and inconsistent with how this court has read similarly constructed law. Applying a more natural and appropriate reading of the section in question has the direct consequence in this case of limiting the claimants to those individuals who are physically or mentally disabled who actively use a service animal for the enjoyment of their housing accommodation. The result of that would be to prevent the plaintiff in this matter from having a prima facie case and effectively having standing to sue under Section 4582A. The second issue is that the court, in pulling from federal guidance under the Fair Housing Act, improperly imposed what is effectively a strict liability test.
Counsel, I see that the green light is on.
Yes, Your Honor.
And so what I'd like to do is turn to the language of Section 4582A sub 3. And you and the Maine Human Rights Commission have both talked about various canons of construction. But isn't it as simple as this? To read it as you suggest, there is a missing preposition. In other words, if you take out the phrase, or otherwise discriminates, right? So that the last phrase is intended to modify or go with the phrase as you've indicated, there's no preposition. It would be any of their agents refuse to permit the use of a service animal against an individual? Or is it refuse to permit the use of a service animal an individual? There's a missing preposition if we were to interpret it. So it only makes sense to separate those two clauses, because otherwise it would say permit the use of a service animal by or otherwise discriminate against. Isn't that?
I don't think that's correct, Madam Chief
Well,
Justice.
how can you read it? How can you read it out?
So the consequence.
Where's the preposition?
I don't know that it hinges so much on the existence or non-existence of a preposition. I don't think that there's any magic wording. I think
Read the sentence to me.
Yes.
So that that last part applies to the part that you want it to apply to.
So if I could, Your Honor, I think the example that would be a little bit more easy to work with
I'm
would
assuming
be.
that means you can't.
No, I can, Your Honor. I'm trying to offer an explanation with this example first, and then
Okay.
I'll come back to the statute at issue. The word "or otherwise" does directly refer back to the prior prohibition, and in fact brings them together as a unifying thought. In the same way that if you go to a park and if there's a sign that says "Park goers shall not feed, touch, or otherwise disturb the geese," we don't read that to mean that park goers are prohibited from feeding universally, touching universally, or specifically disturbing the geese, right? So that prohibition would not be read to mean that you can't hold your girlfriend's hand in the park. There's not a prohibition on touching. So the natural reading or otherwise is actually tying together the shall not or refuse to permit the use of an assistance animal or otherwise discriminate against. That's a unified series against an individual with a physical or mental disability who uses an assistance animal.
Yes,
But
but then it means permitting the use of a service animal against an individual.
Or otherwise discriminate against. No, I think, again, it's a unified thought. It's prohibited under the Act to refuse to permit the use of an assistance animal or otherwise discriminate against a particular class of protected persons. Now, the problem with reading the statute as the lower court did is that there's no qualification whatsoever. If we really take the court at its word and put a stop at refuse to permit the use of an assistance animal, what that means is that denial to anybody the permission to use an assistance animal is a
Sure.
violation of the law.
Sure, because if somebody who may be contemplating getting a service animal says, oh, I need to find an apartment. Oh, they won't rent it to me, and I guess I can't go live there if I get a service animal.
What if it's just any action of denying the use of a service animal for any reason for anybody, even a person who is not disabled?
Well, it would be a little hard to have a service animal if you weren't.
I struggle to follow that logic, though, and it was proposed by the Commission. The Commission's, and this is the Superior Court's fear, too. It's a fear that's born out of hypothetical, that's not borne out by the facts of this case, and not really applicable to real life. Certainly, as I point out in the briefs, a person may possess a service animal that is not owned for their own disability. If my brother, who has a service animal, were to pass away, it's not as though the service animal goes into an incinerator. It's property that can be conveyed to another family
It's
member.
not a service animal anymore if it's not serving someone who's disabled.
Under the definition, that's not true, though.
So under your interpretation, if I don't have a service animal yet, but I know I'm getting one, and I'm looking for a place to live that I can bring my service animal, you can refuse me under your interpretation of the statute, correct?
It depends.
On?
It depends on, again, what animal are we talking about, and is there a reasonable accommodation? So I think the problem with the premise, Your Honor, is that it assumes that there is no remedy for any person to ever acquire a service animal who does not already own one. In fact, there is, and it's just the reasonable accommodation law that's been on the books before the service animal.
Well, there may
law
be
was
other
there.
remedies, but we're looking at this statute.
Right.
And this statute says that you can't, refuse to permit the use of a service animal.
Right, and Your Honor, I think my point is that it's a false choice to say that if we don't interpret it this way, a person who does not have a service animal can be refused to acquire a service animal. And the Commission also concedes in their brief that you don't need to ask permission in the first place. I don't understand what a landlord would do to prevent a person, short of falsely...
Say no dogs. Really? Not even a service animal? No dogs. Wouldn't that sort of prevent somebody?
The Commission says no, because that permission is not necessary, and the person can still go out and get a service animal.
So is this a different case from your perspective if Mr., whatever his name was, if the
Engstrom?
person in this case,
Yeah,
my brain
Sproul.
was going dead there for a minute, Darryl Sproul, if he doesn't have a dog when he calls, and we're assuming the facts are as the judge found them, right? But if he doesn't have a dog when he calls, but he's been told, let's assume in this case, again, hypothetical, I understand these aren't the facts, that the doctor told him you really need to have a dog, you need to have a service animal. He's looking for a place, and he's getting the service animal tomorrow. Is that a different case? and he does in fact get the service animal the next day, but goes somewhere else.
I think if he has a service animal,
I said he got it the next day after the
if he has a
conversation.
service animal, he's protected under the Act.
And so if he got the service animal, he doesn't have it when he has the phone call, and he gets the animal the next day, still no claim?
And I still think we're worrying about something that the legislature might have
It's a hypothetical, I said
already
that.
considered, right. The legislature, in its wisdom, might have the active use of a assistance animal as a prerequisite to asserting any claim under that section, for the very reason that a hypothetical animal is impossible to know whether it's going to be acceptable within the
But isn't that
context of the case.
exactly why it makes sense to draw a bright line in the legislation to say you can't refuse to rent to somebody on the basis, or you can't refuse to permit the use, rather, it's not refusing to rent, but refuse to permit the use of a service animal. It just makes it a black and white, bright line.
I think it's an inoculation for a disease that does not exist. It's not necessary
Legislature's been known to do that.
It's not a remedy that the legislature needed to address, because if a person does actually get the dog, there is an animal in evidence to ascertain whether or not it imposes safety concerns for other residents, or it might be destructive, and those are valid reasons for denying a service animal or
But isn't the
refusing to permit
problem
it.
here that you simply cannot send somebody away? I mean, that by saying, again, taking the facts as they were found here, you're basically saying to somebody before they even step in the door, get out of here. And most people aren't going to, push that.
I don't think that's what's being said. I think the problem of a hypothetical animal is that you're expecting landlords to agree that there is permission for that animal to come in before we know anything about the animal. And I don't think the legislature is asking landlords to do that.
Well, it's a service animal. And yes, we are asking them to agree that he's allowed to bring in the service animal. Isn't that the purpose of the statute?
Once there is an animal in question, yes, but a hypothetical mountain gorilla.
Well, let's assume that we're reasonable people here, and you have a reasonable construction, and the agency has a reasonable construction, and the language is ambiguous. Don't they win because we defer to their reasonable construction as the administrating agency?
I don't think that them just calling it a reasonable interpretation.
So you're saying theirs is
Right.
unreasonable?
Yes, Your Honor, I am, because the statute, the natural language of the statute requires the active ownership of a service
So
animal.
if we take that as a tipping point,
Yeah.
and someone calls up and says, I have a service animal, footnote, I have a disability, can I rent at your place? And at that point, if the landlord says, no, you can't, is that a problem?
That would be a different case.
Okay, so another person calls and says, I have a disability, I'm going to get a service animal next week, can I rent at your place? Then they can say, no.
It's also a different case from this case.
I'm
because-
trying to parse,
understand
I'm
that.
trying to get the purpose with what the statute is trying to prevent prospectively going forward. And the line you're drawing is, if I've got my dog here, then I have to say, yes, you can come in, but I haven't got my dog yet, but you still can't come in.
Well, I think the line that I'm trying to draw, Your Honor, is what the legislature has created, right? And if we look at how this court has ruled itself in the Dussault case, when there was a similar construction as between the refusal to rent, and if I can just finish this thought, Madam Chief Justice,
You may.
the refusal to rent or otherwise discriminate against a person who's receiving Section 8 housing, the court, even though there was a dissent, they all agreed that it was a limited prohibition only on recipients of Section 8 housing, not a blanket prohibition on refusing to rent to anybody.
Thank you.
Thank you.
Everybody see it okay?
No, I can't read it from here, but that's okay. We don't usually use things like that.
Is that in the appendix?
Is that in the appendix?
That's not in the appendix, but I did contact the chief clerk, Matt Pollock, about
Okay.
including the visual aid, and he approved it.
Okay.
I can take it down if
He
you like.
didn't tell us, but that's okay.
Excuse me. Good afternoon, and may it please the court. We are here today to ask you to uphold the Superior Court's ruling. In his 1997 book, A Matter of Interpretation, U.S. Supreme Court Justice Antonin Scalia warned against, quote, presumptions and rules of construction that load the dice for or against a particular result. When he wrote about such dice loading, Justice Scalia was worried about judicial overreach. But his warning also hints at a more insidious problem inherent in statutory interpretation. That is, if you stare for too long at any paragraph, sentence, word, syllable, or phoneme, especially out of context, you risk overanalyzing the text and depriving it of its most straightforward meaning. Furthermore, the canon of construction that you choose to interpret the statute also bears a risk, because it can consciously or unconsciously steer your interpretation toward a biased or predetermined result. In other words, instead of reading the law to determine what it says, you run the risk of framing the law to say what you think it ought to say. But sometimes a cigar is just a cigar. That is why courts, including this court, have held to the principle that they only look beyond the plain meaning of statutory language when that language is ambiguous. It is our position that the language of Section 4582A, subsection 3 of the Maine Human Rights Act is not ambiguous. It is, in fact, straightforward. And while it may be a complicated sentence because of its structure, it has a list of subjects, it has dual predicates, and the absence of an Oxford comma, which I personally find abhorrent, but that's a style choice and neither here nor there. Do not confuse complexity with ambiguity. There are three segments to our argument. First, as already discussed, the meaning of subsection 3 is plain, and the court does not need to look beyond that plain meaning to find in our favor. Second, even if you find there is some ambiguity in subsection 3, our interpretation of the statute is reasonable, and this court defers to an enforcing agency's reasonable interpretation of the statute. Third, appellant's interpretation is not reasonable. It does not accord with the rest of the Maine Human Rights Act, and this court should not entertain it. So before getting into the plain meaning of the statute, I want to focus a little bit first on what's probably our winning hand here, which is agency deference. So even if you think that I'm out of my mind when I say there's no ambiguity in the statute, and even if you think appellant's argument is actually quite reasonable, we still prevail in this case. Less than a month ago, on April 10th, this court held in Eastern Maine Conservation Initiative versus Board of Environmental Protection, quote, if the statute's language is ambiguous, we defer to the interpretation of the agency charged with its implementation as long as the agency's construction is reasonable. In other words, it doesn't matter which of our two interpretations is more reasonable to you. The standard is whether the Commission's interpretation is reasonable, and if it is, you uphold it. So with that said, I'm sorry if you can't see it, I brought in this visual aid which basically diagrams the sentence, because subsection 3 is really just a long sentence. So first, before I get into that, the plain reading of the plain reading of subsection 3 and
Well, the green light's on, so I'm just a little confused by this argument because you say we should defer, and you cite our most recent argument, but you started by citing Scalia. And he doesn't believe in agency deference, does he?
To be honest, Your Honor, I don't know if he believes in that or not.
He doesn't.
I think but the reason for me,
Because your primary argument is that we don't need to defer because the statute's clear on its own.
yes, Your Honor, that's exactly what it is.
Scalia wrote Chevron.
Okay, so turning to the plain reading of the statute, this is how the Commission reads it, and this is the plain reading. It is unlawful for an owner, et cetera, to, 1, refuse to permit the use of an assistance animal, or 2, otherwise discriminate against a disabled individual using an assistance animal at the housing accommodation.
So can I suggest that it is as simple, and your diagram helps and shows this, that the preposition follows only the second clause, and it's not a preposition that works with the first clause?
That's exactly true, Your Honor.
Because it would have to say, refuse to permit the use of an assistance animal by, it would
Right,
have to
or-
have a preposition to rejoin.
Or something along those
Or something.
lines.
And that's similar in Dussault, when we were looking at section 4582, that statute talks about discrimination to refuse to rent or impose different terms of tenancy to any individual who is recipient of Section 8 funds. And the same preposition works for both clauses.
Yes, Your Honor. So in this case, as you can see, there's two independent clauses here. They're both branching down from the initial, from the subject here. The top bracket there is the subject, which is the list of individuals to whom the law applies. The predicates, the verbs expressing what the subjects are prohibited from doing, are the two brackets underneath. The first clause, we know it's a clause because you can put a period there, and it would be a complete sentence. It would be a standalone sentence. The second clause might be a little bit more tricky because there's other things going on here. You mentioned the preposition. But how do we know that it's an independent clause and not simply a series, as appellant asserts? There's a few clues. First is or. We discussed that in our brief, that the function of or
He doesn't like your rule of or.
It's not my rule, Your Honor. The function of or is to separate or disjoin two things from one another, and in this case, is separating independent clauses. But the other clues are pretty inherent there, too. So otherwise is a clue. The Cambridge Dictionary defines otherwise as meaning differently or in another way, and it also as meaning except for what was just referred to. Otherwise is a conjunctive adverb, so it's a lot like however or therefore. And its grammatical purpose, and this is a quote from Strunk and White, is to connect independent clauses by showing that there's a relationship between the ideas expressed in those clauses. So the word otherwise is telling the reader that the thing before it is related but distinct from the thing that's coming next.
And there are two groups of people. In other words, not everybody who uses a service dog has a physical or mental disability. There are people who train them, et cetera. And some people who do have physical and mental disabilities have not yet been assigned service dogs, and that appears to have been the case with Mr. Engstrom.
Yes, Your Honor. We were particularly concerned about that second case that you mentioned.
So they're really two distinct, they aren't they don't protect synonymous groups of people, in other words.
Correct. Yeah, exactly, Your Honor. So the next thing that the Chief Justice actually already alluded to is the preposition against. So a preposition is a word that relates an object to another word in the sentence, and it begs the question, against what? It must be against something. It must be a noun or object. In this case, it's linking the direct object there at the bottom, which is an individual using an assistance animal at the housing accommodation, to the verb discriminate.
The appellant points out that we ordinarily and frequently look to federal law to interpret our statutes. Is there an analog in federal law to this subsection?
I am not sure, Your Honor, but I know that I do know of the precedent that says we looked to federal application
There's not a
of the law.
specific provision about service animals in the federal analogs. You have to go into the guidance and things like that, and you draw it out from the ADA and the FHA. And I had a question about a statement that was made in your brief, which said that if able-bodied person asked a landlord whether they allowed service animals and the landlord said no, that the able-bodied person wouldn't have standing. But the jury's still out as to the federal counterpart on that. That's the Atchison case, where they declined to address that issue with testers. So it's still an open question. You don't even have to be potentially someone who's disabled to have standing to challenge someone who's refusing to have service animals admitted. Is the agency, the commission, taking the position that that's not the same rule that you don't follow that federal law?
No, we're not taking that position, Your Honor. The highlight in the brief was mainly just the hypothetical situation. I was unaware of that case, personally.
I mean, the fact that the jury is still out as to whether you can test with able-bodied people under the ADA, say, or the FHA, would suggest that you don't have to have even be disabled to be able to ask the question, and then if they don't answer the question the right way, it's a violation.
Well, Your Honor, I mean, that falls under the Maine Human Rights Act in a different way, under subsection 1C, which prohibits making discriminatory statements that...
Which is the alternative basis for this, right?
Exactly. You're right.
And it wasn't really discussed a lot in your brief, so do you want to elaborate at all on that?
Just to say that really the analysis of both are very similar. right? Because in both cases, you have a discriminatory statement being made. The first, the one that we're focusing on here in subsection 3 really cares about the discriminatory effect, and that effect is apparent here. Mr. Eggstrom did not rent the apartment, didn't even apply, and ended up not even getting an assistance animal after this whole encounter because he was so discouraged. But in a situation where, a similar situation where, I guess the discriminatory statement itself would fall under the subsection 1C of the Housing Provisions of the Maine Human Rights Act.
And that doesn't require an intent?
No,
Is that an
but it can include
alternative?
intent. It doesn't require it, but it can include it.
Sure.
So it specifically says it's unlawful discrimination to make, print or publish, et cetera, a statement that indicates any preference, limitation, or discrimination based upon disability or an intention to make any such preference, limitation, or discrimination. So intent could be a factor, but it's not necessary.
You said you could put a period after that first clause there, an animal, basically, that's an owner or lessor who refuses to permit the use of a service animal. If that can stand alone as a grammatic sentence, but I'm wondering what it would mean in isolation like that. So if there's owner of a housing project and there's somebody across the street uses a service animal, they can't simply say to them, you can't use that service animal because there's no authority there. It has to be somehow connected with the person who uses a service animal on the premises.
Yes, Your Honor.
So doesn't that lend support to what the plaintiff is saying here, that it really does require contemporaneous use of a service animal in order for this entire sentence to have effect?
I don't think so, Your Honor, because grammatically, so the statement to refuse to permit an assistance animal is broad enough that it includes that situation, but it also includes all these other situations that we've been discussing here. Like, for example, in Engstrom's case, he didn't have one yet, but he still refused to use one at the property. You have a situation where maybe somebody, when they rent the property initially, is not injured or is able-bodied and then later becomes disabled. and
Isn't
then
the
needs
problem
one.
really that in your diagram, that last phrase, i.e., at the housing accommodation, really is back where the two independent clauses are joined?
Right.
That's a limitation on the first part of refusing to permit the use of a service animal.
And the other thing to keep in mind is if you wanted to treat this as a series here, so you would have to be able to move that modifier there at the end to apply to each predicate, and it would have to make sense in each case. And as the Chief Justice already pointed out, there's no preposition there for one, but I think even if you entertain this idea, and even if we put a preposition like of in there and entertain this idea, it still doesn't make sense. So if you take like a simple sentence like, Mary, I won't have to diagram this one, Mary likes to hike, to swim, and to ride a bicycle, right? In that situation, a bicycle can only logically apply to ride because you can't swim a bicycle, right? But if you wanted to say Mary likes to hike, to ride, and to swim at night could apply to all three, and you could just insert it into the sentence at either point. Well, if you try to insert that section here, if you want to eliminate the second predicate and just take that direct object and insert it there after refuse to permit an assistance animal, you run into some problems. So it would say, so I'll just read it. So it would say, it's unlawful for any owner to refuse to permit the use of an assistance animal of a disabled person who uses an assistance animal at the housing accommodation. So it's very awkward. It's redundant, but it's redundant in two meaningful ways, right? The first way is in style. Refuse to permit the use of an assistance animal of a person who uses an assistance animal. It sounds silly, it's just repeating itself. But it also repeats its concepts, right? So the first statement is broad enough to encapsulate the direct object on its own. It doesn't need it there to modify it. So that's just evidence that it's not intended to modify it. Whereas if you apply to the second predicate, it's necessary for that second predicate to make sense because of the preposition. You can't be against nothing. I see that I'm running out of time here, so really I just wanted to close by saying the purpose of the Maine Human Rights Act is to protect individuals from discrimination. It protects individuals against the landlord's preemptive refusals to rent based on their disability and their need for an assistance.
Finish your sentence.
Thank you, Your Honor. But the MHRA is not ambiguous. The Commission's interpretation and enforcement of subsection 3 is based on its plain language and we ask that this court continue to defer to our expertise on the matter.
Thank you. And do I understand that appellants are having different counsel argue the rebuttal? Okay. It's a little unusual, but
You don't mind, Your Honor?
go ahead.
I would like to begin by thanking you for the opportunity to handle the rebuttal. I would like to, while I appreciate the importance of the syntactical and grammatical disagreements we've had thus far, I would like to approach the problem from the other direction, the practical results of the trial court's ruling, which is that, I think we understand that generally a landlord has the ability to exclude animals from property if they want to.
Pets.
The problem with
They don't have the right to exclude all animals.
Understood. A landlord has the opportunity and the right to exclude pets from leased property if they choose to. The problem that we run into in this particular instance is when that becomes discriminatory, right? Because we impute a discriminatory
But
intent.
your co-counsel argued about, it doesn't make sense, it's overbroad, all those things. But isn't the fact of the matter that it is an appropriate and sensible bright line? Because when a tenant calls a landlord, the landlord doesn't know whether that person is disabled, whether that person has a service animal, or whether that person is qualified or entitled to have a service animal. And so if somebody's going to make rental inquiries, ought it not to be uniform and have the answer not depend on all of those things? And you just can't say, I don't, would it be okay to say I'm not going to rent to a disabled person? I mean,
Sorry, I did not mean to interrupt you, Your Honor. I think
isn't
to
that
an
the
extent-
equivalent?
I think to an extent, Your Honor, it has to depend, because I think without allowing it to depend, just exclusively say that you can't allow pets or you're not allowing pets, I think is just
Well,
results in a
I
default
understand
finding.
that, but
Right.
that, as a matter of fact, that's not what the trial judge found. The trial judge found that although the first sentence of no dogs was okay, it's when it's combined with the second part of it, which is even, service animals or federal or assistance animals federally recognized. Yes, even those. As a matter of fact, you may disagree that that's what happened, but that's what the judge found.
Yeah, I think the result of that inquiry, the federally protected dogs language,
Finish.
I think that imputes a finding of a discriminatory intent, but I also think conversely, the trial court also found that our client, the defendant Daryl Sproul, had no discriminatory intent associated with his no-dog statement.
Thank you.
Thank you, Your Honor.
As is our usual practice, counsel, we will be taking the matter under advisement and issuing a written decision in due course. I also understand that both for Mr. Susi, which is why we gave you the opportunity, as well as for Mr. Hurd, that these are your first arguments, and it is our tradition to ask you to come back and take the greetings of the court, and we'd be happy to see all counsel.
All rise. Court is in recess. You're going to want to follow this gentleman right here. Entirely up to you, my friend. We got it.
And good afternoon, you can be seated. The matter before the court is Kennebec 24-423, State of Maine versus Michael Greenleaf Jr. We are being streamed, both audio and video, live on the web. If counsel would identify yourselves by saying your names for the record, please, together with the party you represent.
Good morning, Madam Chief Justice. I'm Attorney Derek Banda. I represent the appellant Michael Greenleaf Jr.
I'm Tracy Duvall, I represent the state.
Thank you. And Attorney Banda, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Your Honor. Madam Chief Justice, honorable members of the court, as I stated, I am Attorney Derek Banda. I do represent the appellant Michael Greenleaf. This appeal before the court presents an opportunity for the court to address situations that arise when juries indicate that they're deadlocked. And it presents an opportunity for the court, in this particular case, to correct an error where it is the court, not the jury, that is placing undue emphasis on certain jury instructions.
Can I, the green light is on. Can
Yes.
I clarify, I know that the judge did not give some instructions that you requested.
Yes.
But you also seem to be raising an issue that overall instructions that were given were too coercive. And I guess I want you to parse out what you are, with regard to the situation here, what it is exactly that you would ask us to hold.
Thank you. So it started with note 4, I believe. I'm not really claiming any error with regard to notes 1 through 3. I think I made that clear in the brief.
Yes.
So this started with note 4. And note 4 was a note indicating, it was essentially, we'll call it the second deadlock note. But the second deadlock note was unique in that the jury just didn't just say that they were deadlocked. They said, quote, "The information that is necessary to achieve a unanimous decision is not in evidence." And so instead of asking the court at that point for a finding of, or moving for a situation for manifest necessity and asking for a mistrial, my position was that the court, so starting with note 4, what I had asked for was something akin to or similar to Alexander's 612. Alexander 612 is sort of fashioned or titled as the missing witness instruction.
Right.
Obviously, we did not have a missing witness, but the substance of that instruction, I think, would have been helpful for the jury because it instructs the jury that they must decide the case based on the evidence presented to them.
And I understand that you made that. So my question really was a little simpler. I understand the instructions that you thought the judge ought to have given and didn't. My question is there an error in any of the instructions that were given?
Yes. So the response to note 4, we're still on note 4, instead of giving what I had asked, the court instead fashioned a response where the court gave, again, the OUI instruction. And the jury had already heard that instruction twice, so they heard it in the...
So it may have been surplusage, but why is that error?
It's error because it was highlighting undue emphasis on that particular area of the case. As the court is aware, the OUI instruction, mental or physical faculties impaired to any extent, however slight, that's certainly an instruction that, from a defense perspective, we only want said once. It was given, they asked for it again, they were given it a second time. When the deadlock note came out on note 4 and said, we don't have all the information here necessary to reach a unanimous verdict, if you look at the context of the trial, there was only one thing missing. And the evidence that was missing was the evidence of what the BAC was at the time of driving. The officers testified that they couldn't say what the BAC was at the time of driving. The chemist,
But
Maria
that's
Pease...
your interpretation of the note.
Well, I think that's the only interpretation. The chemist, Maria Pease, testified...
But to the chief's point, there's nothing legally incorrect about what the judge instructed.
It's putting undue emphasis.
Undue emphasis. but I'm seeing if I can get you to answer this question. Was there anything legally incorrect about the four corners of what the judge said?
If legally four corners means we don't put undue emphasis on instruction.
That's where I'm trying to get. So your point is you wanted something else, you felt this emphasis. I don't know if I agree with your statement that it emphasizes it. It puts this, the court has already made it clear that the burden's on the state, and they must prove that his faculties are impaired, however slightly. That is the standard. That's the black letter book rule on it. There's nothing wrong with it. And if we were to find error on the part of the court for instructing a legal, making a legal statement that you felt was not in your client's favor, we'd be upsetting an enormous amount of jurisprudence.
Problem, Judge, is they said they were deadlocked twice. And the rules change when that happens. It's not the same, the rules on jury instructions change when jurors say they're deadlocked.
Right, and there's a
particularly twice.
standard instruction given at that point, not the dynamite charge, but something else. And the court here is very clear. It says, if after further deliberations you still believe that you cannot reach a verdict, you should advise me of that in writing. What can be clearer than that?
And that wasn't done in response to Note 5, where the court specifically left that out and left out the path for the jury to reach an end state or an end result where it did not make it clear to them in response to Note 5.
But Note 5 was asking the court for a transcript of Hodges' testimony. They wanted to look at the evidence again. Why would the court give the deadlock instruction after that request? And he did.
Well,
He gave them what they're asking for.
He also, because we had the debacle with Note 6 by that time, and so he also went into, and I haven't talked about Note 6 yet, but the handling of Note 6 was probably the most problematic aspect of this case. But we had already had the debacle of Note 6. So when he gave the re-instruction about Note 5, he went into, in part, about how don't tell anyone about your verdict, and then the last sentence, remember, you must not tell anyone, not even me, individually or collectively, until after you've reached a unanimous verdict. Doesn't tell them there at the end of that they don't have to reach a unanimous verdict. Doesn't tell them that they don't have to
Why would
not
he
surrender
be
an honestly held belief.
Why would he be telling them, if you still haven't reached a verdict, let me know?
Well, he started it. He started telling them this, and then he failed to give them the path of.
But in Gantier, we said, even when a judge did not repeat the caution, when we've got a deadlocked jury, that was or had already been given, that they should not surrender his or her honest belief, and do not merely for the purpose of returning a verdict. And we've said that that is coercive only when the instruction that is given includes a mandate to reach some verdict, or an instruction to change an opinion if convinced the opinion is in error, or a warning about the cost and consequences of a failure to reach a verdict. And he didn't do those things. I mean, he'd already given the other instruction. He didn't repeat it, I get.
He also had repeated the OUI instruction. The real problem here is Note 6.
And is there anything that was inaccurate or misleading about that OUI instruction?
It was
I know you don't
missing-
like it.
It was missing necessary material.
Can we
In
talk
the
about?
OUI instruction?
No, the response to Note 5, I thought was your
Okay.
question.
Can we talk about what you're calling the debacle of Note 6?
Yes.
Let me tell you what I think happened. You can correct me if I'm wrong. The jury officer goes into the jury room, and some juror, not the foreperson, slides a note, and the jury officer picks it up and takes it to the judge. And in the meantime, it's not clear where this came from. The foreman confirmed that no, that note was not supposed to go out, and it was later determined that it wasn't a note from the jury. The judge never looked at it. It was like a non-factor. What am I missing there?
Well, what's missing is the court officer testified that this note was given to her just like all the other notes. It was transmitted to her per the court's procedure. There
Well,
was
she
no
didn't really
discussion.
say it was given to her just like all the other notes.
Didn't
She
she say
said she picked,
it was
yeah, it
slid
was
to her by
slid.
one of the jurors, not the foreman?
Well, there was nothing unusual or untoward that stood out about the transmittal of this note, is I think what her testimony was. There was no discussion by anyone or qualification. It was given and transmitted to the court officer in a routine.
By the foreperson? Was it transmitted by the foreperson?
I don't know that testimony was the foreperson. I think it was on, I think her testimony was that it was given to her by someone in the jury.
Now, wouldn't that be an exception to the normal way that notes are handled?
No. No. There was nothing unusual or untoward, certainly to the court officer, about how she received that note. And she certainly was under the impression that that note was given to her to give to the court, which she did. Now, where I think the mistake lies is the court should not have had 1 out of the 12, and I don't care if it's the foreperson or not, 1 out of the 12 cannot intercept and unilaterally decide to intercept a note that's been transmitted to the court in accordance with the procedure that the court sets out. What the trial judge should have done is received it, opened it, talked about it with counsel, and then when he discovered that it said we're deadlocked, there should have been some inquiry with each member of the jury, similar to what's laid out in Alexander 8.7. There should have been some inquiry with each member of the jury. Are you deadlocked? Did you intend to transmit this? Would further deliberations alleviate the deadlock?
So if juror number 3 sends out a note that somehow makes its way to the judge and says, we're deadlocked, that triggers an obligation by the court to inquire, to jump into the deliberations at that point, even though the foreman has not said anything?
Well, Judge, we don't know. That note was, as far as we know, was written and signed by the foreperson. There's no evidence that note, there's no evidence that.
How do we know that?
Well, there's no evidence that the note was done by any other juror but the foreperson.
I thought the foreperson testified at some point that
No.
it wasn't supposed to go.
No. There's no evidence as to who comprised the note. The evidence is that the note was given to the court officer just as, and she interpreted it as a regular communication to the court. There's no evidence that that note was by a rogue juror or any other juror other
She
than the
says,
foreperson.
as I was returning to the jury room to bring them back into the courtroom, I was advised by one of the jury members, I'm not sure if it was the foreman, that there was another note. So I said, okay, it was slid towards me, I grabbed it from the table.
Right, and then on cross-examination, I think I asked her whether there was any contemporaneous discussion or anything, and she said no.
Right.
There was no qualifying or qualifying discussion on the way. The note was transmitted to the court in the usual course of business, and it's not for one juror to unilaterally intercept that or to stop that process from happening.
And but they hadn't, like, said, we have a note or anything like that. She testified, Deputy Marshal Lovering, that she had gone there, everybody was already standing, she'd gone in there to tell them we're getting ready to come back in the courtroom, and it was at that point that this note gets slid across the table, right?
Well, they were already on their way down.
Yep.
They weren't in the room they were already on their way down to the courtroom.
They had started walking to the door.
So that's why, she didn't come out and knock and say, we have a note. She was already on her way down with the jury at that point.
But doesn't that indicate that the jury didn't necessarily ask her to transmit it to the court?
We can't assume that, Judge. We have to follow, when we're dealing with jurors, particularly in a post-deadlock situation, this would have been the third deadlock note. This would have been the note 6 was the third deadlock note. We can't assume that. We have to follow the procedure.
Thank you.
Sorry.
Did you want to ask something?
Thank you.
I know, that's why I said thank you. You looked like you were going to ask something. Attorney Duval?
After that conversation, I'm not sure if I should start with a note, but I just wanted to mention the HGN first, because we did not address that. The officer in this trial testified, her words regarding HGN was that in her training, she understood that 6 clues of HGN indicated that the person was over the legal limit and impaired and should not be driving. She was instructed to not use any numbers, and she didn't. Her definition of over the legal limit was that they were impaired and should not be driving. It was not a particular number. In fact, when Mr. Banda asked her about a particular number, a .08, if she would arrest someone and charge them with OUI under that number, she said yes, and she had done in the past. So the state believes that her testimony was absolutely above board, that she was allowed to testify to that. She did not use any numbers. I want to go to the notes now while it's fresh in my memory. The note number 6, is that the one we're talking about? The court officer testified that that was not the normal course. I have it right here. It's in her testimony. She said, that's not the standard protocol on note passing to parties. She stated that she went to get the jury for the previous note so that they could be told that they would be allowed to watch the officer's testimony. While the jury was walking in the courtroom, one of the juries at the end, who hadn't started walking yet, slid the note over, and she grabbed it. And once she brought it into the courtroom, and the court officer started to hand it to the judge, a number of people in the jury made noises. The foreman said, wait, stop, you're not supposed to get that yet. So that note was never intended to go to the judge at that point. And the only reason the court officer even knew what it said was because she looked at it when she was walking into the...
It wasn't folded up like the
Correct.
usual?
She saw something about a hung jury or a deadlocked jury. And that's the reason that we even knew what was in the note. Because ultimately, the judge was told he wasn't supposed to get the note. The judge gave back the note to the foreman. And then the foreman and the rest of the jury was told that they were going to be allowed to hear the transcript of the officer's testimony. in its
Did you
entirety.
object to the instruction of the jury that, about, can't speculate, I know it's not really 612, but can't speculate about evidence that may be missing?
Yes.
Why?
Because it's a missing witness. The judge looked at it, he said, this is about a missing witness.
But you have a note that says, there's evidence that's missing. Why would you not instruct the jury at that point to say you can't speculate about anything that you think is missing, not just a witness, but evidence that you may think is missing?
That one was about a witness, and the judge, in our discussions, I and the judge thought it would be confusing, because the jury had its evidence. And if we start giving them an instruction about missing evidence, a missing witness, that would just be very confusing to them. It
I guess
didn't fit this case.
how is it confusing to say don't speculate about evidence that hasn't been put into evidence?
Because it specifically talks about a missing witness.
Well,
And
I
think they would
understand it
speculate.
does, but if Mr. Banda was asking that it to be altered and talk about don't speculate about missing evidence, not just a missing witness.
I don't believe he asked that it would be altered.
Oh, that's how I read it in the transcript.
Does the transcript, I don't recall, does the transcript include the usual instruction, members of the jury must decide the case on the evidence presented to you, and any inferences you can draw from facts proven to your satisfaction, and not speculate on what otherwise might have been, that sort of generic instruction?
I think so, but I can't swear to it.
Okay, all right, we'll
not-
check the transcript.
Yeah, I think the following instructions certainly were clear. I know Mr. Banda complained about the instruction after note number 4. Number 2 questioned, they said they might be deadlocked. They didn't say they were. And note number 4, we had a conversation about whether it should be a deadlocked jury, and we all agreed, no, let's keep going. That was a conversation we all had. Then it was, what instructions does the judge give then? And the judge decided, I think looking at jury notes, looking at them as a whole, the judge decided that his instructions after note number 4 would be detailed. It went over, it said it wouldn't go on forever. The judge talked about the presumption of innocence. The presumption of innocence, it's the state's responsibility to prove beyond a reasonable doubt. The judge defined OUI again. The judge talked about a deadlocked jury again. And the judge, in response to note number 4, in his instructions, he said, if after further deliberations you still believe that you cannot reach a verdict, you should advise me of that in writing. So the judge did that after vote number 2 and 4.
Should the judge have given a more specific instruction after Officer Hodge testified that the results of the HGN test indicated that the person was over the legal limit, they're impaired and should not be driving?
No, because Justice Mitchell thought that that was an appropriate piece of evidence, that she could testify to that.
But it's black letter law that she can't quantify
Correct,
the
and she
result.
didn't. She said over the legal limit. And
Yeah, but-
in Maine, over
but
the
you're-
legal limit is not an 08
Well,
necessarily.
except, that really is. I mean, everybody knows that the legal limit is 08. The judge then tells them that the back is, the BAC, one of the alternatives is over 08. And we have said in Taylor that you cannot use the HGN, it's improper to use the HGN results to quantify the blood alcohol content. And isn't that what this officer did?
No, we do not believe so. I did not believe so, and Justice Mitchell did not believe so. We believe that.
But don't we get to decide?
Yes, you do. That's one of the reasons we're here. But over the legal limit in Maine doesn't necessarily mean a number, and she didn't use a number. She didn't use a percentage.
Well, we didn't say that in Taylor. I mean, I understand that's what the testimony was in Taylor, but we didn't say that, did we?
That it could not be quantitative, and the state does not believe that over the legal limit means a .08. It means much more than that. It could be an 0.7, it could be an 0.6 if they're impaired, and so it's not necessarily a number. I don't think over the legal limit has a definition, at least at this point.
But it does sort of imply some sort of metric, doesn't it?
It could be a number, or it could be that they're impaired by the alcohol they drank.
I mean, I agree with you, it's not as specific as Taylor. Taylor was very specific, of 10%, 77% of a .10 or something, but when you talk about a limit, you are talking about, in standard parlance, everybody talks about the limit is .08. I mean, it's pretty close to the line, and I don't, you said earlier that she was trained in that manner. I would suggest somebody may want to speak to the trainers and.
Well, they're trained numbers, they're trained percentages. Like if they have 6 clues, there's 10% chance or 77% chance or over number. So we told her you can't say any of that, you can't use numbers. You can talk about impairment, you can talk, and this is what she came up with, and the state.
There was
she
a
didn't use
lot of
numbers.
evidence about being impaired in this case,
Yes.
wasn't there?
There was a lot of it.
So if it did cross the line, is there a pretty strong argument it was harmless?
Yes, absolutely, Your Honor.
He said he was buzzed, right?
Yes, he said he was buzzed. He said he had 2 big drinks that were like the size of a fishbowl. They were very good, they were very strong. He said he was buzzed. He stated he was a 4 on a scale of 1 to 10, that he felt the alcohol. In the booking room, he asked when he found out the test result, he asked if he could just try again later, if he could sleep it off. So
He was stopped because he was going the wrong way
Yes.
on a one-way and driving in the middle of 2 lanes, correct?
Yes,
And he was coming from Cancun.
yes.
I mean,
Those are the big drinks.
But yet the jury was pretty deadlocked, wasn't it? It was pretty close. I mean,
Well, it sounds like, we're not supposed to know this, but we do, that it was 8-4 from the very beginning. I'm guessing 8 guilty, 4 not, but I don't know for sure. We don't know. But they did pass a note to the court, even though they weren't supposed to. So it seems like from the very beginning, some were convinced one way and some were convinced the other way. But they kept trying to do their duty. They kept trying to come up with a verdict, so they kept the conversation going, and they would send these notes along to try to figure out how can we come to an agreement.
but isn't that exactly Attorney Banda's point, that this is a case where it wasn't just a momentary, for a moment that they seemed to be deadlocked? We know from the notes that they sent that they seemed to really struggle with getting to a verdict. And then, under those circumstances, doesn't it become even more important to ensure that the instructions that are given at that point are not coercive and that are appropriate?
And the state believes that instructions were non-coercive and appropriate. And this note was a lot like State v. Braddock. In that case, the jury note said, "We are a hung jury, we are looking for more information and do not feel it's available. We know this is not possible." And the defense wanted a mistrial, and the court said no and read further instructions. And this court in Braddock said, "The jury may have then thought that a unanimous verdict would be impossible without more information. But that belief was not any different from the circumstance of a jury that thinks a unanimous verdict is impossible, because at that point, no juror seems likely to change their minds. The fact that the jurors have indicated they do not have enough information does not require a declaration of a mistrial. Instead, giving the approved supplemental instructions is proper." The state believes that's what happened here.
There don't seem to be additional questions. Thank you.
Thank you.
Mr. Banda? Going to the HGN issue, I know that when you objected when the testimony was given, and then the judge deferred ruling on the objection. When he said he was not going to exclude that evidence, did you ask for any curative instruction at that point?
I think there was a discussion at sidebar that I said the law court's going to think that I've waived this if I don't keep objecting. That's somewhere in the transcript.
Well, okay, let me ask it. I don't recall that you asked for a curative instruction at that point. I know it was much later than when the testimony was actually given. Am I wrong on that
I
recollection?
don't remember.
And so can you address the issue of harmless error on that issue? There's plenty of other evidence. Even if it walked close to the line, it clearly didn't go as far
I
over as
understand.
Taylor.
I understand, and it may be harmless, but because we don't know what the jury was hanging their hat on, but here's the thing. They came out with a note saying that if there's all this evidence of impairment, as Justice Connor says, there's all this evidence of impairment, okay, well, why didn't they find him guilty? No, they sent out a note saying we're deadlocked. And they sent out a note not only saying we're deadlocked, but they sent out a note saying the information we need to reach a unanimous verdict is not in evidence. So all that impairment evidence that's supposedly so great, and by the way, the only reason why he went the wrong way in front of Cancun is because they had this testimony that there was barriers that were set up for outdoor seating because of COVID, and they had actually changed the traffic pattern there. But if there's all this other evidence of impairment, then the jury should have found him guilty. They didn't. They said, no, the information necessary is not in evidence. The only thing that wasn't in evidence that we talked about continuously was the fact that no one could say what the BAC was at the time of driving. The officer said that. Maria P. said that. We can't tell you what the BAC is at the time of driving. So then they sent out a note. The information we need is not in evidence. I asked the court for an instruction to say, don't speculate, even though that Alexander's template talks about missing witness, what we really want to talk about is they shouldn't be speculating on things that haven't been presented. The court refused to give that, and instead repeated the OUI instruction, mental or physical faculties impaired, however slightly to any extent, putting undue emphasis on that. And then we get into, of course, what happens with the later.
Was it undue emphasis, or was it, the court's assumption was that they didn't understand the definition of the elements of OUI?
Well, the state cited Braddock, and in Braddock, the court didn't sua sponte decide what to give for re-instruction on the law and re-instruction on evidence, like happened here. No, in Braddock, Justice Alexander, I believe, inquired, are there further instructions or further readbacks that would help you reaching a verdict? He just didn't decide, well, I'm going to pick this particular instruction and give it to you again. And that's what happened here.
Thank you. Thank you, counsel. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, I believe we're in recess for the day.
All rise. All persons having anything further to do before the Honorable Justices of the Supreme Judicial Court, sitting as the law court, you may hence depart and give their attendance here at 9 o'clock tomorrow morning, as this court now stands adjourned. God save the state of Maine and this honorable court.